Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the Phia Group.
Welcome to another episode of Empowering Plans with the Phia Group. My name is Cindy Merrell. I am the Director of Legal Recovery Services here at Phia, and today I'm joined by Compliance Attorney Bryan Dunton. Say hi, Bryan.
Hi, everyone. Nice to be back.
Thanks, Bryan. I always enjoy our conversations because I'm on the subrogation side, you're the compliance side, and we always have a good time trying to figure out what we might want to talk about that's relevant, that we both experience. And today's topic is definitely something that we are both experiencing every day, and I know it is affecting our plans. So what I'm talking about right this moment, listeners, is I get an email and I'm, in my everyday, I'm asking a plan for let's say, a 2024 plan document or whatever document they have in place for the time of loss that I'm working on. And what happens is I get an email back from the plan. I'm really excited because I'm going to go jump in and look at that plan language. And it's like a 5 years, sometimes 6 years, sometimes more than that, year-old plan. And that immediately makes me jump into, hey, thanks for sending this over, but it looks like this is, a little older. Do you have any newer documents? And as soon as I get that reply that says, nope, that's it, this is the plan document that's in effect, I know that we might have a bit of a problem. And what's that problem? It's legacy language. If you didn't hear me, I said legacy language. It's old contracts, old governing documents, and old assumptions. These documents, these legacy language, it creates a compliance risk for a lot of our plans. Most compliance issues we deal with don't come from plans trying to ignore the law or trying to cut corners. They come from documents that were written for a regulatory world that no longer exists. We're talking business agreements, vendor contracts, stop-loss policies, and even the SPDs that I'm working with every day in that example. Sometimes these documents haven't been reviewed or revised in years. Even though the rules for transparency and privacy and even fiduciary oversight have changed multiple times over since that document was created. When the law changes faster than the contracts, and any legacy language remaining becomes an immediate risk. So today we're going to talk about areas of the law that they're very different at first blush. It may cause failure points for our clients in very similar ways. First, we're going to dive into HIPAA Part 2 with a focus on how it affects downstream recipients of substance use disorder data. Then we're going to shift to PBM transparency and reform, and where the new law will force plans to look hard at PBM agreements. It's all about governance and what happens when old documents and contracts are not keeping up with new laws and regulations. So I think it makes sense for us to just level set with everyone. How does a self-funded plan typically operate? It's not just through that single document or a single vendor. Bryan, can you tell us a little bit more about how this happens?
Yeah, happy to, Cindy. So plans operate in a host of different layers. Obviously, the plan document, the summary plan description, that's part of it. But there's also layers of administrative service agreements, business associate agreements, those contracts with your vendors, even stop-loss policies, plus any other internal policies or procedures you have too. So like you alluded to earlier, many of these were drafted years prior, might have been amended incrementally, but otherwise they're quietly carried forward year over year. And despite that shift in the legal landscape, that we've talked about already, this language remains. So that's where you see that creep of fiduciary risk. Certainly, fiduciaries can delegate various functions to their vendors, but they can't delegate the responsibility itself. So that expectation that the fiduciary understands where that vendor is going, what they're doing, what the governing document actually allows for, and making sure that it aligns with the current law is really important. On our side of the company, when we hear clients say things like, well, we've always done it this way, or that's just how it was negotiated, or our vendor handles that for us, those are big triggering items for us to say, oh boy, there might be a bigger problem behind the scenes here. So I think it makes sense to start the discussion with HIPAA Part 2, because that's really a perfect example of this. A basic assumption we've heard since these changes were first announced over a year ago is that Part 2 only applies to substance use disorder treatment providers. So facilities, programs, clinics, things like that. But that's somewhat incorrect and a little overly broad in its interpretation. Part 2 isn't just a risk that exists with who creates the record, it's who receives it next. So that's where plans, TPAs, your PBMs, any kind of utilization management or care management vendor, that's where they all come into play. And if you're a plan that uses some kind of analytics platform, they get dragged into this too. Part 2 follows the data. So that label as an entity isn't the only thing that really matters here. So from our side of things, we've seen confusion and even outright statements from plans where they say, we're not a Part 2 program, so this doesn't apply, or we comply with HIPAA, so that's that. And when the analysis stops there, that's really a problem, because it misses part of the point here. The issue isn't just whether the plan itself is a Part 2 program, it's whether that substance use disorder, that SUD information is flowing downstream to any of your vendors or your plan itself in ways that your contracts never contemplated because they never had to. And once you have this kind of PHI moving forward, that protected health information, and once it moves downstream like that, Part 2 triggers for anyone else that's receiving it as well. So this is where we really see those old documents show their age, so to speak. We'll see, to a lesser extent, business associate agreements that need to be updated. But more importantly, the notices of privacy practices, those NPPs, they treat substance use disorder information like ordinary PHI. They might not even mention Part 2 requirements at all. So there's no appropriate allocation really of that responsibility for pre-disclosure. In some cases, we see that impact stop-loss policies, because those policies too assume some kind of unrestricted claims data sharing, which Part 2 doesn't necessarily allow in all these instances. So a lot of these failures end up being related specifically to the documentation. It's certainly not for a lack of intent to try and align with the law. This is really poignant. Obviously, relying on older language is a problem, and it needs to be updated. And for us, this is really timely. We're recording this on a Wednesday, on the 11th of February, and the rules for Part 2 are expected to be complied with by February 16th, which is the following Monday. So this is a good last-minute reminder. If you haven't dealt with reviewing your BAAs or your NPPs to make sure they're updated, now's the time to do it, so you can try and be as proactive as possible about it.
Yeah, and Bryan, one thing I have to point out that you had mentioned before, and I loved this. Bryan sent me, when we were talking about this, he pointed out that fiduciaries are allowed to delegate functions to vendors, but they cannot delegate responsibility. So this is a great reminder for everyone. I love how we're talking. This is an opportunity, something that's immediate, something that plans are facing right now that they should be looking at. And speaking of right now and hot off the press, not too long ago, Congress enacted PBM transparency and reform provisions as part of the funding minibus that President signed into law on February 3rd. This is known as the Consolidated Appropriations Act 2026. Can you tell us more about that, Bryan?
Yeah, I can. This is not surprising, right? We've seen a lot of this over the last year and a half at the state level. We've seen some attempts at previous legislation, even from Congress itself. We've just never seen anything get across the line here at the federal level like this. Um, Directionally, it's really clear. Transparency is coming. Fiduciaries are going to play a key role in this. The requirements here with the CAA are going to come online in 2028. And we think a lot of folks are probably going to misunderstand what's about to happen, because this isn't some kind of rote paperwork exercise where the PBMs are just going to, that's pharmacy benefits managers, sorry if we hadn't said that before, but it's not just that they're going to have to provide more information to you, and it's just going to be a whole pile of paperwork to look through. There's certainly a contract comprehension aspect here too. What you're looking at is that contracts with PBMs will need to be reviewed. Fiduciaries are going to need to understand exactly how that PBM is being compensated. So this is where we see that legacy language could become a problem again. Historically, PBM contracts use undefined terms for fees and rebates. They can at times blur distinction between direct and indirect compensation, and they can even reserve broad discretion without, significant clarity on what that actually means. Stop loss policies play a role here again, right? References may exist to outdated reimbursement assumptions, which aren't even allowed under this law anymore when it finally goes fully into effect. So just like part 2, if the contracts don't describe that legal reality properly, then you've really got a compliance and fiduciary risk sitting squarely on your table. Some really key features here that this law is going to now require is mandatory uniform contracting terms for both the PBMs and the employers, which is good. There's going to be an increased disclosure of rebates, fees, and compensation from the PBMs. It's going to require 100% pass-through of rebates to the plans, which is huge. The plans should see a benefit there. Importantly, it will also prohibit certain PBM pricing practices for employer-sponsored plans. So spread pricing, which is a term you hear a lot when we talk about PBM reform, that would be one of the things that you would see affected directly by this. On the data side, you're going to see a lot more granular drug level pharmacy specific data that's made available to the plan sponsors to dig through, and that there's rights to audit the PBM deals as a part of this new law. So from a fiduciary aspect, you have an additional responsibility now to audit these PBM deals, make sure that you have the best deal available for your plan and that they're abiding by these new rules and regulations. And with the additional information and data that's going to be made available, that burden falls squarely on the fiduciaries. It's going to be harder to try and skirt that. So I think it makes sense to take a step back here as we try and wrap things up for you. Some common threads here. When you zoom out, obviously it looks like PBM transparency and part 2 requirements look pretty unrelated, but as you zoom in, there's some pretty common themes here, right? Laws change, vendors adapt. Sometimes that's unevenly, sometimes it's not at all. When that happens, there's a risk that those contracts do get frozen in time. And you might see those older documents that are from 2019 or hopefully not any later than that. And plans can sometimes wrongfully assume that there's alignment here with the new laws without actually checking the documents themselves. And when compliance is always about knowing that rule and where the rule lives in your documents, it's really, really important that you go back and double check and make the changes that are necessary. So for brokers, this is a real chance for value add on your part to highlight these kind of issues proactively for your plans, for your TPAs. For TPAs, this is where process and clarity matter the most for you. And if you're a fiduciary, I mean, oversight lives and breathes with you. So this should be a good note to walk out on.
Yeah, Bryan, I'm thinking about this, and those are some really good suggestions. I don't want any plan to get stuck in the situation where they're sending us old language and operating under that. What are some other things that a plan should do?
So I think a good place to start is, to a lesser extent, look at your business associate agreements, see if they need updating for Part 2 compliance. It's more likely that you're going to need to update your notice of privacy practices to align with Part 2, especially if you receive or maintain any of that Part 2 protected SUD data that we were talking about earlier. Um, Certainly, our consulting and plan drafting teams were very well equipped to handle this. With that deadline coming up next Monday, we've seen a huge influx of questions and concerns related to that. So, if you're one of the people that has questions about that, we're very well equipped to help you. Um, Regarding PBM reform, we also recommend looking through the contracts there. Look through those PBM agreements and see if there's provisions that are going to require updates. So, if there are audit clauses, look at the changes that are going to need to be made there. Any kind of data access provisions are almost assuredly going to need to be updated. Any kind of compensation terms, they're going to need to align with what the new rule allows for too. And certainly review your stop loss contracts too. Anytime you're going to change any of this language, there's a chance that it's going to create a gap if one wasn't already there, or maybe expand a gap that already exists. But our consulting team can handle that too. We review stop loss contracts pretty routinely for this kind of thing, and PBM agreements as well. So if you do have questions or concerns about this, the Phia Group's very well equipped to take care of you.
Well, thanks, Bryan. And, as always, we are here to help you. If there's anything that our compliance team can help, they are so fast and so on point. I love working with them. Thank you again for giving us some insights on the pitfalls of legacy language, and you gave us some really great practical advice moving forward. Thank you,
Thanks so
listeners.
much.
My name is Cindy Merrell, again here with Bryan Dunton. Thank you so much.
Have a great day, everyone.